Hear ye. All persons that have anything before the Honorable Justice of the Appeals Court now sitting in Boston, phone within the Commonwealth. Draw near, give your attendance, and shall be heard. Let's see the Commonwealth of Massachusetts. The school is now open. Please be seated.
Morning. Thank you. Good morning.
Good morning.
Welcome to the Massachusetts Appeals Court. My name is Judge Desmond. To my right is Judge Shin. And to my left is Justice Singh. We'll be your panel for all 5 cases today. As you know, 15 minutes per side with no rebuttal. I take it. Familiar face. I know you've practiced here before. So we're familiar with the arguments and the record. So you need not spend a lot of time going over the record, but to make your points. We know the facts. And so with that, Attorney Tompowski, our first case is 2022 P0872, Commonwealth v. NICCO-KAWON C. Pledger.
Good morning, members of the court. Michael Tompowski for NICCO-KAWON Pledger. Mr. Pledger is entitled to a new trial for several reasons. First, I'll briefly address the court's recent order regarding the Guardado case and its impact on the convictions here. And I believe the parties are in agreement that counts 4, 5, and 6 do need to be remanded for a new trial based on the remedy laid out by the SJC in Guardado, where there was no evidence one way or the other as to the defendant's status as a license holder.
I'm sorry, I thought there were only 2 firearms convictions. Did I miss one? I thought one was dismissed.
5, right?
Yeah.
You know, I apologize. One would have been dismissed as duplicative
Right.
perhaps after the
So
verdict.
there's a carrying a firearm without a license and then carrying a loaded firearm. Those are the 2 that remain, correct?
Yes, that's
Okay,
correct, Your Honor.
thank you.
I apologize. He was convicted of 4, 5, and 6, but
Right.
then one was dismissed already as duplicative. The more substantive issues in this case are challenging to be sure, but there's 2 that I'm going to address today, unless the court has questions on any of the others. The first is that a trial counsel was ineffective in a couple of ways, in failing to challenge the expert testimony of Cy Ray, who testified as to the cell tower data in this case, at a pretrial Daubert hearing, and failing to consult with and potentially call as a witness his own expert. And both of these errors by counsel went to critical issues in the case because the cell tower evidence was a substantial part of the Commonwealth's proof at trial.
Do you agree that, at least with respect to your first round, it was a strategic decision made by Attorney Belzos not to call his own expert?
Well, that's what he said. So I quite frankly, I think it
He
was...
said under oath, right?
He wrote it in an affidavit, yes. I think my position is that was a post hoc rationalization, quite frankly, as to why he didn't do it, because there's actually no reason not to attempt to challenge the expert testimony.
At the time of this trial, had Ray's testimony been excluded in any other court?
No.
Okay.
No, it had not. But there were people...
But it had been admitted in other trials. Is that fair to say?
I don't know that that's on the record one way or the other, quite frankly, Your Honor. But contemporaneous with the challenges, contemporaneous with other trials where defense attorneys were challenging this, this trial took place in that context. And I'm not saying that counsel should have anticipated some future court's decision, but when you're trying a murder case, you know, it's your job to be at the cutting edge of technology and of the law, and this was the critical issue in the case, and at a minimum, he needed to explore it. And so to come back after the fact and say, well, I didn't explore it because I thought better strategy would not be to, I think it's not a reasonable strategy if it really was one.
Did he say that he had prepared by looking at Ray's prior testimony in other cases?
He indicated that he felt he could, through his own work, develop a sufficient cross-examination that would be enough.
Did he say that he had prepared by looking at Ray's testimony in other cases?
I'd have to go back to his affidavit for that specific point, Your Honor, and I don't remember if he said that specifically. He indicated he talked to other attorneys about Ray, and based on that, did not feel that he could mount a challenge. I think that, quite frankly, that is not sufficient to defeat this claim, because if you actually look at what we developed in the new trial record, that at the time there was substantial, there were people out there in the field who had very strong opinions about Mr. Ray's work. And it was counsel's obligation to challenge this evidence in whatever way that he could. So either by filing a Daubert challenge, or if he decided that that would be frivolous, I guess he could abandon that. But there's no reason not to have consulted with an expert to at least develop the cross-examination as fully as possible, or to call as a witness.
In his affidavit, trial counsel says he consulted with other attorneys as well as people with professional training relative to CSLI, and he came to the conclusion that a different expert would have given essentially the same testimony. And that was, I think, the real crux of the motion judges, who was also the trial judge, her decision. So.
Right, and both that opinion by counsel and by the trial judge was just wrong. And so what we're saying was the best practice here is not necessarily that Cy Ray's testimony would have been excluded altogether. We challenged specifically his testimony about the location of the cell phone. So,
are you saying, why is it wrong? Are you saying if the Commonwealth had put a different expert on the stand, that expert could not have given testimony saying that this phone was in these general locations at the time of the crime?
Correct, right. So what another expert would have said was that the phone was connected to a specific tower.
And from that connection, you're saying an expert could not have said this is the general location of the phone? I don't see in the Nichols affidavit where he ever says I or a different expert would have testified this way.
What Nichols says is in his affidavit is that CSLI can give you macro locations.
But to what degree of specificity in a city like Boston? The affidavit doesn't say anything about that.
Well, what he says is that that Cy Ray's testimony was junk, essentially, that you cannot draw a shape that represents.
Yes, he picks apart Ray's testimony, yes, but he never says what a different expert could have testified given the number and locations of cell towers in the city of Boston. That's what is missing, as far as I can tell from the affidavit.
I believe what he said in his affidavit was that you can tell macro locations and not micro locations.
What does that mean? What does macro locations mean?
It says you can tell you're in one city versus another.
So you're saying that if the Commonwealth put a different expert on the stand, all they could have said was this phone was in the city of Boston as opposed to the city of some other city?
I believe if you're asking me what I believe would be proper, it would be for an expert.
That's not the question.
You're saying Nichols' affidavit establishes that if a different expert had testified, all they could have said was this phone was in the city of Boston at the time of the murder.
Within the coverage area of the tower, not the so-called handoff area, which is what Cy Ray testified to, which is a much smaller subset
but
of the coverage area.
They could have pinpointed the location of the phone with greater specificity than just the city of Boston. Would you agree with that?
Coverage area of the tower, and they could have said what the general coverage area was, which varies depending on buildings and terrain, of course. But no one can say exactly what the coverage area is, and maybe it would be more refined than the entire city of Boston. But Ray invented an entire subset of coverage area and calls it handoff area, and someone needed to testify that that wasn't science, and that's what defense counsel needed.
Did it come out that the phone was actually found outside of that blob? We're talking about the blobs and the wedges when you're talking about, I think he said the blob includes the handoff areas.
The blob is what he called his estimation of where the phone was at the time the call was made.
And it turns out, I think as a matter of fact, that that the phone was found outside of his blob.
So the co-defendant's phone, which was at a fixed location because they found it on the street, was determined to be just outside of the so-called blob, yes.
Did they find that one on the street or in the car?
I'm using that term colloquially. Yes, it was at the scene. Yes.
I heard you say the best practice would have been, but that's not our standard.
Of course it's not. I understand that. But if you're talking about what counsel should have done, I'm trying to, I guess, identify that versus what was done, and what he should have done is something far more, is what I'm arguing. That essentially the decision not to challenge the evidence, I think, quite frankly, he can say it's strategic now. I don't think that really holds up if you look at what was going on contemporaneously with this trial and two other cases that were decided just after this, that these challenges were being developed. And the second failing, not having an expert at all, there is no justification for that, and he doesn't even attempt to supply one. Why not attempt to call as a rebuttal witness an expert? Why would that have made a difference? Because someone needed to say that Ray's handoff area blobs were not based on science.
Did you think that Attorney Belzos did a good job effectively attacking his credibility on cross-examination?
I say he did a serviceable job, and I always, it's always amusing to me when the Commonwealth compliments the trial attorney, right? The appellate attorney misses the mark, misunderstands the law. The trial attorney did a great job with cross-examination. He made, I think, 3 points, basically, fundamentally, on the science. He did say something about him going to an online school. That doesn't really go to the science. That goes to just his overall credibility. That he didn't validate his findings, that no one else uses the blobs, and that he relies on data that no one else uses. And that, it made a few...
Not effectively calling it junk science?
No, I think he's saying maybe you're pushing the envelope of the science, but what someone like Nichols would have said, if you read the affidavit, 30 pages or something, he says, here's why this is made up. And so Ray called it an estimation, and what Nichols would have said, and what the defense attorney should have argued, is an estimation is a fancy word for speculation, right? That you can't, from the data, possibly say that the phone was in the subset of the coverage area known as the handoff area. It's impossible. It can't be said. Coming from an expert's mouth versus an attorney attempting on cross and then in closing to convince the jury of that is 2 very different things. And there's absolutely no reason why you can't do both. In other words, what is the reason of just saying, I'm going to wing it and do my best?
If defense counsel had presented an expert, they would have been subject to cross-examination. So he says he was concerned that it would open him up to cross-examination, and he would essentially have to agree that this phone was in the general locations of the crime.
Within the coverage area of the towers, yes, he would have to
So
agree.
why is that manifestly unreasonable?
Because that fact wasn't particularly in dispute, but in this case, the actual micro-locations, the specific location of the phone, not just generally within the coverage area, but being on a specific street, was critical. And that's why the Commonwealth employed Ray for this purpose, because they knew that they couldn't just say he was in Dorchester.
So a different expert would not have been able to testify that the phone at one point was in the location of centerfolds, and later in the night it was in at the location of the murder?
I think what they would have been able to say is that it connected to a tower, a specific tower, if that tower was near centerfolds, and that's what they could have said.
And what's the mean? And then that establishes it was in that location.
I don't think it establishes it. The Commonwealth can argue that. They can argue it as an inference, but it's a far cry from saying, here's an inference the Commonwealth gets to argue in closing, versus here's a witness that gets to say it directly. And the courts draw that line all the time. There's some things that witnesses get to say, and there's some things that attorneys get to argue, because the courts understand that it's much more forceful for an opinion to come out of an expert's mouth, like the defendant is guilty. We don't let experts say that. The Commonwealth gets to say it, but we don't let experts say it because we understand that that sways the jury much more significantly than hearing it during a closing argument argued as an inference. So yes, the inference would be the phone was somewhere near that tower. But that's very different than someone coming in and drawing a shape and saying, I believe the phone was actually on this block. And that's what counsel should have challenged more forcefully.
So I think we understand it. You also talk about the jury section.
Yeah, so I want to just, with my last minute, address the juror compensation issue. We raised a challenge to that, that it denied the defendant of a fair cross-section. The Commonwealth says, well, it only applies to the veneer. That's not true. It applies to the petite jury, to the trial jury as well.
Blacks were seated on the petite jury.
There were.
How many?
How many? Yeah. It was a diverse jury.
How many? How many?
It's in my brief, Your Honor, and I don't have I'm sure the Commonwealth can tell you the exact numbers. There were several jurors of color on the jury, to be sure. But there were 4 specific jurors who, because of financial reasons, could not sit. And my argument is that either the statute is...
Were they of color?
Yes.
Were there some who couldn't sit for economic reasons who were white?
There were some who were white and some of a race that is not apparent on the record. And my argument is that either the statute is unconstitutional, as it will have the effect of depriving jurors from a socioeconomic background that can't afford.
Constitutional as applied?
Facially. And as applied, as it had the effect in this case of depriving him of a fair cross-section, and that the judge, either sua sponte or defense counsel, should have asked for increased compensation as they're entitled to do under the statute that I cite in my brief. And if there are no further questions, I will rest.
Hearing none, thank you very much. Attorney Jordan.
Good morning. May it please the court. Darcy Jordan on behalf of the Commonwealth. I would like to acknowledge members of Alex Bryant, the murder victim, are present in court today. And I'd also like to acknowledge the trial prosecutor, Craig Iannini, who really wanted to be here today but had a conflict he couldn't move. But the Commonwealth is asking this court to affirm the conviction of this defendant for murdering Alex Bryant and for armed assault to murder Daquan Brown. Now, I think what we have to really look at this ineffective assistance claim is really the big picture of what Attorney Belizos, who is now Judge Belizos, what he really had to grapple with and what kind of strategic decisions did he have to make with this evidence, specifically the phone tower records, right? Because at the end of the day, he knew it was coming in, whether it's Cy or another law enforcement, as he describes in his affidavit. And I do want to let the court know that that is correct. He consulted with experts. He looked at previous testimony where Cy had testified. So to say that he didn't do his homework is, I think, not accurate. But I think what really had to do, and I think if I could just kind of look at the big picture of his strategy, was that he knew that there was going to be tower evidence of this phone around the murder scene. But more importantly, it would also be this phone was being used at the time that the defendant was at the party earlier, and then it would also be used at Centerfold where he's picking up Lisa Lewis, and then back to the murder scene and is present pinging off of towers at the murder scene. Now, as an experienced attorney, he knows he has to make a decision. Am I either going to deal with it and grapple and have some credibility before the jury, or am I going to, out of hand, just ignore it, essentially, and try to attack it that way? And I think if...
And not call his own expert.
Because an own expert would have affirmed everything that Cy said, which would be, not everything, I take that back, not everything, but the meaningful nuggets, which would be, based on the telephone records, the Sprint records, those records have which tower the phone was using at the time.
Some of those things, I apologize for interrupting you, were some of those things confirmed by the T-Mobile expert that was called by the co-defendant?
So I think the question is, did the T-Mobile expert confirm that the records indeed showed those things? I think the T-Mobile expert did go through the T-Mobile, but the phone that we're talking about is actually a Sprint phone. But I think for the jury's purposes, it was clear to the jury what those records alone show. So regardless of whether there's any testimony. Now, testimony would necessitate to explain this column means this column means this. But this tower, when we look up the in this instance, when we look up the Sprint phone's records, is connecting with this tower, we know the stationary tower is here. So Judge Belizos knew that was going to come in some kind of form. So he did do his homework to assess, well, how is this going to come in? I have no reason to think that if I do a Daubert-Lanigan, this is going to be excluded.
But he says in his affidavit that Cy Ray's had been qualified as an expert in previous cases. Are any of those available before the trial in this case? I know you cited 2 federal district court cases after.
If my belief, I'd have to do a Lexis search, but my belief was that Cy Ray, this might have been the first time he was admitted in Massachusetts, but he had been allowed to testify in other states. So the idea of Cy Ray being qualified and expert in jurisdictions was not foreign. He had not been challenged. And I do want to point out, I know we're talking about thereafter, and of course the meaningful point for this court's assessment of this claim is that the time of the Judge Belizos' decision.
A lot of the cases afterwards, he's coming. Right?
Sure, but I think that loses the fact, because I think Cy Ray is still being admitted. This testimony is, and I think we could dive into quibbling about how those evidentiary hearings went. I don't think it's a slam dunk to say out of hand that Cy Ray is junk science. I think that's not the question before the court, but I think it's I think it's too simplistic to say that this evidence is junk science. It's out of hand all day long. We know it should have been rejected, and therefore would have had, again, what this court has to look like, whether or not the defendant in this case was deprived of defense. And I don't think, not only does the record bear out beforehand where Cy Ray was admitted in other jurisdictions, it doesn't bear out how these facts in this specific case, with the choices that this defendant, with this defense attorney had to make with this defendant, because there's other facts that buttress CSLI, right? CSLI on its own is not meaningful. There has to be other circumstantial evidence to color what that means.
That may be true, but there's a reason that the Commonwealth chose Cy Ray, not another cell phone expert, right?
Yes, I think at the time, Boston Police was using Cy Ray's product at the time, and
it was a one of a kind.
And he was one of a kind, and well, I think the one of a kindness we also have to be careful with, because it is based on proprietary information. Now, Apple records, and Apple is constantly being admitted in evidence, and they have a propriety thing. So, and that's only really goes to one factor in the Daubert-Lanigan test. So, I think again, and I understand that this isn't the question before, but I think it has to color what the defense attorney was thinking at the time, right? And I think to say that that these blobs, if you actually look at the record, you could see that defense counsel's cross-examination was successful, because in the closing, the prosecutor shies away from the handoff areas, the blobs, and says, hey, pretty much what I just said to this court. At the end of the day, you cannot dispute that these phone records are bouncing off these cell phone towers in the location. Whether or not it's how precise it is, sure, that's an inference to be drawn, but that's not the meaningful evidence in this case, because there is no doubt that these records show, as I explained, those 3 meaningful points in time that this phone was being there. And there's a lot of other circumstantial evidence that I think that the defense attorney also makes a strategic choice to just not quibble and say that phone is not associated with this defendant. So, and I also want to point out, if you, again, a careful looking at the record, what the defense attorney also successfully does is he shores up the educational backgrounds of all the other forensic witnesses to be comparative against Cy Ray. And as the Commonwealth in its closing and its brief points out, he does a very good job of using the T-Mobile's testimony that I would argue is in line with the proffer that my brother makes about Nichols. So to somehow say that an expert witness from the defendant who would have to concede really the rudimentary points that this evidence is admissible in the courts, it basically not only was it not ineffective, that this was ample representation, but it was effective in that how it was handled by the Commonwealth.
What do you say about the jury selection?
Are we talking about the statute or the preemptories? So The preemptories, as I discussed, I think it's a blanket statement. I think this record is really difficult, is not a sufficient record even to raise these claims. I think since this case, the SJC has really give a better understanding of how to keep notes and how to preserve the record and preemptory challenge claims. So I think, unfortunately, I think the court and the attorneys didn't have that benefit. For example, although there is a challenge of 2 black jurors in this case, we are missing information about the race of the comparative jurors. And I think that alone makes this claim fail, because if the argument is a comparative category of, I think, what is not accurate of being criminal defendants, even if we assume that, we don't have the comparative race and gender of those other jurors to say that it was a disproportionate application.
Do we know what the composition of the petite jury was at the end of the day?
I have to admit, I had trouble figuring it out, again, based on this record. And that's not to say that some of these claims we could make inferences, but I think that's dangerous when we're coming to these kind of claims. For example, you know, some of the attorneys will refer to people as sir or husband, and I don't think we can make those conclusions when it's this important kind of question. So I think that's one of the challenges this court's going to have in figuring it out. So as to the total petite jury, there definitely were black members of the jury on there. I think it's difficult to determine what gender they were. I have
Not interested in the gender right now.
or the race. Well, I say gender because sometimes for example, it'll be black woman, and then it'll just be like man. And again, you can make inferences, but that's not how this court has to grapple with preemptory challenges. And I think at the end of the day, regardless of the comparative, if we're saying a disproportionate application of the preemptory, I think it is clear on this record that the judge found that the explanations offered by the prosecutor were genuine and adequate as to both. So one juror was the one that had served a prison sentence, and there's cases, I cite them, that talk about this idea of somebody that has served a sentence or has extensive experience with the criminal justice system might harbor ill will toward the Commonwealth, or in this case, I argue, that might have a benefit to the defendant, because if we recall, he was facing first-degree murder. So at the end of the day, if this is a conviction, he was facing a mandatory life sentence. So that factored in. And there was no question whether or not that was genuine, and it was personal to this juror, as in there is no question that that was indeed only that juror. And if we turn to the second juror, the woman that had been prosecuted by our office and had said she had felt she was an example, I think that's a very clear-cut example of that being not only a genuine offer by the prosecutor, but specific to that juror and in this case, because it has to be both, right? Because that's, again, a meaningful thing as it applies to this case.
And just briefly, would you touch on the economic hardship?
Yeah, I think, again, back to the record, I think this record, the defendant can't even raise this claim in this record for a few reasons. And then if I can turn to maybe the constitutionality question. The record is not clear about everyone's race and gender, which is meaningful to this question. And then there's objections made to white jurors, but there's some objections not made to some of these people being excused individually for hardship. There's no mention of either. So unless we have a total understanding of what we have, I see the record not being sufficient on that purpose alone. My brother is...
What's the mechanism for raising a claim like this?
So, and I think that's a good question, because I think it's raised kind of awkwardly, because it's a constitutional challenge to a statute that allows for a trial judge to use discretion, and then it's claiming a Sixth Amendment right to a fair cross-section claim. So I feel that's like an awkward piecing together of the harm affected, if that makes sense. But to raise a claim for Sixth Amendment cross-section, you have to, the prima facie case that it affects a distinctive group, which, as I mentioned in my brief, I think my brother has a difficulty siloing what that distinctive group is for some of the reasons I just mentioned, these other kind of objections regarding race and gender. The second part of the three-part test is that there has to be a showing that, and again, this only has to do with venare. My brother's incorrect. This has to do with the cross-section of the venare. There has to be evidence that of the members in the community that they're underrepresented in the venare. So in cases that have looked at this question, there's been census evidence. There's been evidence from the jury commissioner about who the letters go out to, right? Because everyone eligible, well, actually it goes, everybody that might be an eligible juror gets a letter, but then it gets whittled down to who qualifies, and then we get the venare. And then part of the problem we have here is that neither of those things are met in this case, right? We don't have any census, we have none of that, but we only have this venare. And the cases are very clear that these kind of claims can't be raised on one venare. It has to do with part 3, which would be the systematic application to the venare as being basically excluding. And I cite a case, Thiel, that talks directly on point.
So that would apply as well to an as-applied challenge?
So as applied challenge, I think this is where I talk about the awkwardness of this application, because it's the Sixth Amendment which allows for the fair cross-section. So as applied, I feel like it gets kind of confused with equal protection often, because the language about distinctive group is similar, but they're actually really two different rights, because equal protection affects, you have to have a distinctive comparative group, which we don't even have here, so we can't raise it. But the idea of Sixth Amendment claim has to do with who's coming in, who do I get to pick to make my petite jury. So it basically has to be a fair section of the venare, because there is no constitutional right for the petite jury to be an accurate reflection of the community.
But if say, within the venare there were people of a distinctive group were being systematically excused from serving because of economic hardship, that would not support a claim?
Not the way it's raised here. I could maybe, if there's more venare and this idea of what, if I could just back up, because I think part of the problem with the rubric of how the claim is set forward is that they're saying this hardship and the money that is allowed, I see my time is up, if I can just continue my thought, and that the money allocated, they're saying that basically requires an exclusion. So I think for these Sixth Amendment fair cross claims, it doesn't have to do with individual exemptions. It has to do with a broad blanket exclusion. So what you're saying is that if everyone here was exempted after these individual questions, if everyone was exempted, that still would not violate the defendant's constitutional right, because wouldn't be a blanket exclusion.
So you could never bring a claim like this then?
They are raised. If I cite cases in my brief where they are raised. There's I think a Wisconsin case that's been raised. There's an Arizona case, but it has to do with a more global data than the defendant has presented here. So what the defendant has presented only here is that 4 jurors were individually exempt, and again, as compared to a blanket exclusion. So it fails on numerous levels. I see my time is up. Thank you.
Kindly. Your arguments have been very helpful to us. The matter stands submitted. Next case on our list is 23P0783, Commonwealth versus Daniel Arroyo. Attorney Vizone, how do you pronounce your last name?
Yes, Vissone, yes. Please, the court, Joseph Vissone for Mr. Arroyo. We had 2 issues in my brief today. It appears I don't have to argue the first one, so I'll just go right to the second one. Basically, the argument for the second one is this goes beyond just, this notion that a date is not an element of the crime. It's not. But it doesn't mean it's not important in terms of giving someone fair notice of what he should expect at court. And the complaint shows that on 10/22, He was charged with assault, to wit, a table. But there was also, as the evidence showed during trial, that there was also a pushing of his girlfriend into a door jamb or a stairway. And that's clearly an assault and battery, but wasn't charged. There's no date. There's no conduct that says, to wit, being pushed into a doorway, as it was in the other assault and battery, where they said, to wit, headbutting.
But the jurors were, sorry, the jurors were simply instructed that it was an assault and battery, correct? They were not given any other details regarding what they were looking for.
Correct.
And the defendant had notice through a police report regarding the pushing into the door frame?
Yes, but there was no notice in terms of whether or not that was going to be charged or not, whether the police officers believed that, that was an assault and battery. And even if they did, it wasn't in the operative document is the complaint, not a police report. There's a lot of things that appear in police reports that turn out to be, either wrong or non-consequential. But
was there a claim made at trial that this was surprise?
well, that wasn't claimed. I mean, that's why we're in substantial risk of a miscarriage of justice territory with this particular claim. It should have been. I mean, the complaint is very clear, Your Honor, that nowhere in that complaint does it allege any kind of assault and battery conduct on October 22nd. All it talks about is, in count 8, is on 10, I think it was 10-9, there's an assault and battery, to wit, a headbutt. Well, that only happened on 10-14. There was no headbutt on 10-9. There was an assault with a knife, which he was acquitted of, but that's the only assault that there was. And on 10-22, the only assault that there was with the table. There's nothing, the complaint is absolutely silent with regard to any kind of behavior, assaultive behavior, happening on the 22nd. Again, it's not an element of the crime, and I said that in my brief, but it doesn't mean, just because it's not an element of the crime does not mean that there is importance to it. How can you convict somebody of a crime that you have not charged him with in the charging document? And that's basically...
the crime is assault and battery. I mean, that is in the charging document.
Assault and battery on 10-14, yes, the headbutt. She woke up and he was straddling her and screaming, and he went to butt her and missed her jaw and did his nose. And then there was testimony at trial. Certainly there was testimony about him pushing her into the doorway, but
On 10-14.
no, on 10-22.
On 10-22.
On 10-22, but that wasn't charged. I mean, a date is one thing. I mean, if you say on such and such a date, you murdered John Doe. Okay, I murdered John. Yeah, I know who you're talking about. The date was the day before that, but that's here. You're claiming no date, and you're not claiming, what was the kind of assault and battery that you're saying I committed.
Is your argument lack of notice?
I'm sorry?
Is your argument lack of notice?
It's not lack of notice. I argued in the brief that he was not charged with the crime, so you can't convict him.
So you can't just charge, if the complaint had originally just said assault and battery, count 1, assault and battery, count 2, assault and battery, you're saying that that's not a proper charge?
Well, all the charges there have a date. I mean, you have to know when, because there was 2 assault and batteries, I think it's incumbent upon the Commonwealth to differentiate between
So
one
if there is a lack of notice, then...
I'm sorry?
If there was a lack of notice, the defense counsel could have raised that prior to trial. But you're not arguing lack of
Well,
notice.
he should have raised it prior to trial, but he didn't. And I'm just saying that my argument is he wasn't charged with an offense on 10-20. He was charged with one offense on 10-22, which was throwing the chair and missing the victim. and I believe he was acquitted of that. But if they put 1022 assault, okay, which was an attempted battery with a chair, then they could have put on 1022, he assault and battered, the victim, to wit, pushing her into a door.
So you're saying because they put the date in one, they should have put the date in all?
They should have not only put the date, but because all of the other charges said what your conduct was.
Right, well, I mean, you got a police report, you knew what the facts were, the trial counsel knew what the facts were. Were there any pretrial motions for a more definite statement as to what the...
I don't believe so, no. But I guess my point is, he wasn't charged with the conduct that occurred on 1022. There was testimony from the victim that on that date she was pushed into a door jamb, but he wasn't charged with that. The only thing in the complaint it says is that on 1014 he was charged with a headbutt, and he was. But the complaint also says on 10-9 he was charged with assault and battery, to wit, a head, and then count 8, I believe it was, it's the same thing again. On 10-9 he was charged with headbutting the victim. Well, there was, as I said in the brief, and I think everyone would agree, that there was no battery committed on 10-9.
But given that there doesn't seem to be an issue of notice, what is your argument that this, and you're agreeing that there was evidence at trial supporting the separate assault and batteries? What is your argument as to a substantial risk of a miscarriage of justice?
That he wasn't charged with a crime. He wasn't charged with it. You can't just convict somebody of a crime and say on such that you did this, and then it's not in the charging document.
Well, it's in the charging document. Doesn't this go back to the issue of the dates and the significance of the date?
Well, there's two things. There's the date, which is helpful, and then there's also the conduct, which would have differentiated between the 1014 date, which was headbutting, and the alleged 1022 date, which was pushing the woman into the doorframe. So all it said was, the whole complaint was, you headbutted her. You headbutted her on 10-9, he didn't. He headbutted her on 1014, yes, he did, according to the evidence. And then 1022, there's no charge of any pushing people into a doorway. I mean, that's the argument. He wasn't charged with that. If you're not charged with something, then you can't be convicted of it.
So what if they had left the date out?
If they left the date out, well, again, I said in my brief, the date is not, usually the date isn't important, except maybe for an alibi defense. If you say on 10-9 you did A, B, and C, and the defendant says, no, on 10-9, I was out of the state, I was elsewhere, and so it wasn't me. So that's not what we have here, but if you don't have the date correct, you should at the very least have the conduct correct. But they didn't have there's no allegation that on 1022 he did a headbutt, nor is there on 10-9, which is what counts 1 and count 8 said. The only assault and battery that that was proper was the 1014 date when he headbutted. That was the only headbutt.
But at the end of the day, we have evidence of 2 assault and batteries on 2 different dates.
Correct.
And there was notice of the conduct, but the dates didn't conform. And then we have case law that says that the specific date is immaterial in many instances.
I'm sorry, Judge. I'm sorry I interrupted. No, what I'm saying is, yes, the date can be, in most cases, it's immaterial. But, the conduct is never immaterial. And, they never said anything about an assault and battery. If I read that complaint, I would have looked at count 8 and said, ooh, that's a mistake. They've already charged that in count 1. So count 8 is just, it's a nullity.
Was there sufficient facts elicited at trial for the jury to convict on 2 counts of assault and battery?
Yes. Yes. It's just that the second one he wasn't charged with. And to get notice of it, what's in a police report, that's one thing. But, you get notice of it basically at trial when you hear the victim start testifying. You say, oh, well, I knew that was in the police report, but I didn't know they were going to charge him for that. Now, boom, here we are at trial, and I find out, they're charging him. It's not in the complaint, but the testimony is now that I guess they're going to charge him with that. So how do you charge somebody? How do you convict somebody of something that you didn't charge them with? That's pretty much it.
So it came as a surprise to the defense attorney? Is that what I understand you to be saying?
Well, no, it's not a surprise. It's just that you're convicting somebody of something that you didn't charge him with. That's the argument.
I think we got it.
If there's no other questions, I'll take my seat.
Hearing none. Thank you kindly.
Thank you.
Good morning.
Attorney Hall.
Good. May it please the court, Donna Marie Heron on behalf of the Commonwealth. We are conceding on the first count that one of the assault and batteries has to be dismissed as being duplicative of assault and battery on a household member, since there was no specialized verdict slips and no jury instructions on separate and distinct acts. As to the second claim, the evidence at trial clearly established that the defendant committed 2 separate assault and batteries, and any variance between the complaint and the proof at trial clearly did not prejudice the defendant. The complaints did have the wrong dates on them. The Commonwealth concedes that. But as been noted, there was the police report attached to the complaint outlined the 2 distinct assault and batteries on the 2 distinct dates. They were originally charged as assault and batteries with a dangerous weapon in the complaints. Prior to trial, the Commonwealth orally moved to amend them to straight assault and batteries, which was allowed without objection by defense counsel. And I think the biggest evidence that the defendant wasn't prejudiced, if you look at defense counsel's opening argument, she uses this to try to argue that the victim is not credible by saying she claims this occurred on this date, but look at the police report, she's wrong on that date. She claims, she's now saying it's 1 to 2 weeks beforehand, but look at the police report, but as the police report will show you that this isn't correct. So she clearly, defense counsel, was aware of the acts that were alleged and clearly used that in her opening statement and on cross-examination of the victim to try to attack her credibility. And most importantly, there was clearly sufficient evidence established at trial that the defendant committed 2 separate assault and batteries on 2 separate dates, so there is no risk or substantial risk of a miscarriage of justice that the defendant was convicted of a crime that he wasn't charged with or that there was no proof of. And the Commonwealth would ask this court to affirm the defendant's convictions and vacate one of the assault and batteries as being duplicative of the assault and battery on a household member. If there is no further questions, the Commonwealth would rest on its brief.
Hearing none, the matter stands submitted.
Thank you very much.
Thank you both. Our next matter is docket 23P0030, KERI Connolly Aldred versus Stephen J. Aldred. And no appellee in this matter. Attorney Brown?
Yes, may it please the court. Attorney Dennis R. Brown for the plaintiff appellant, KERI Connolly Aldred. So I'm assuming that you've read my brief and you know the facts of this case, which are fairly simple. I represented the husband and the wife 5 years before this
In an
case.
uncontested adoption matter? Is that right?
Uncontested adoption. There were no confidences obtained, no secrets. Everything was discussed between both parties at the time. I mean, the
Husband was adopting the biological daughter of the wife.
the wife's biological daughter. Everybody was happy in that case. There are no controversies at all. I remember when we went to the probate court, the same judge was the judge in this support case, came out on the bench, and there was a party. There there was cake that was brought out, and it was a very happy time, and there was no controversy at any point in time during those proceedings. However, in the separate support case, the husband had been representing himself pro se for some time, and then 5 months or so later, or 7 months or so later, counsel filed a motion to disqualify me because of the
My understanding is that you've represented wife on other matters as well, is that
I
correct?
have, yes, Judge. I've had an enjoyable relationship with Ms. Aldred on a number of matters. And
Had you represented her prior to the adoption matter, or was that the first time that you represented either party?
I believe I had represented her before the adoption on a name change, I think, or some other matter, and none of which was remarkable either. But
Was there anything adversarial?
I'm sorry, Judge?
You mentioned a name change issue. Was there anything adversarial in
No,
terms of the nature of?
There was nothing adversarial. As a matter of fact, the father was difficult to locate, and I don't even remember whether or not we actually got service on him. I think we had to get some service of some sort, but whether or not he actually knew about it, I don't recall. But that was an uncontested matter also. I don't think it was infirmed because of a lack of notice to the husband. I think we complied with statutory requirements.
So here, husband files a motion moving to have you disqualified.
Yes, Judge.
There's
Your
a
Honor,
hearing.
I'm sorry.
There's a hearing.
There was a hearing. Actually, what
Judge
happened...
says he's concerned by the joint representation.
Yeah, the judge expressed his opinion that he was concerned about the appearance of impropriety. It was a spontaneous remark by the court.
And issued no findings with respect to his ultimate
He
ruling.
issued no findings. As a matter of fact, on another point, the case was scheduled to be heard on the motion for disqualification a week or so later. There was a pretrial that was supposed to take place on the day he actually brought the motion forward. He did not, at the time, have copies of my opposition, which contained Ms. Aldred's affidavit and my affidavit. But we did find them that day, and they were given to him that day. He didn't look at them that day. I mean, the record doesn't really reflect that, but he didn't pay attention to the opposition or the affidavits. He took it under advisement. And then without comment of any kind, he allowed the motion for disqualification. So a motion for disqualification presents a serious matter. The person is entitled to have counsel of her own choice, and it's an important right. The case law says that. And the judge, the trial judge, motion judge, was clearly obligated to give this matter some attention. And he was obligated to issue findings.
So do you think we should send it back to him?
No, I think Slade says that it should be vacated. And instructions should be given to him to vacate the disqualification. Shouldn't be sent back to him, Judge. Your Honor, I'm sorry.
Oh, no, I mean, in Slade, I forget, did we send it back for further fact-finding? Or?
No, I don't believe so. My understanding is Slade, I could stand corrected on this point.
Okay, so let's say in that case, let's just assume, I don't know, that we sent it back for further fact-finding, because the judge in that case did make some findings, just we found them inadequate, right? I think that was the posture.
Yeah,
In this case, do you think we should ask for more findings or not?
honestly, I'd like to get back on the saddle again.
What's that?
I used a colloquial phrase. I'd like to get back in the saddle again. I'd like to be representing my client. This is going to delay things. I mean, her case has been going on with other counsel. And I think not. First of all, the facts are unchallenged here. Both myself and Ms. ALDRED suggest that there were no confidences. There was no violation or no even a slight trespass against the pronouncements in Rule 1.9.
Would you say that the support matter was substantially related to the adoption matter?
No, not at all. Not at all. In the adoption matter, the question was whether or not the party, the husband in that case, was a suitable person to provide support and education and rear the child. There's been no issue of that in this proceeding.
The precise might not reappear, but in the initial adoption matter, it seems that there would be a great deal of information that you learn about a party, and that could be used at some future point to the detriment of that party.
Well, there wasn't, Judge, Your Honor.
We can't know all of that, right? We can't know the extent of what was discussed or discovered between counsel and the parties.
Well, you've got my affidavit, Your Honor, and you've got the record from the adoption proceeding, and it was, as they say, a plain vanilla adoption. There were no issues at all, and the record, the adoption proceeding and the adoption was based upon the record that was submitted. There was no testimony offered in the adoption proceeding.
At the hearing, did the husband argue that this matter was somehow substantially related to the adoption matter?
The husband did not. But
He's got the burden?
well, he does have a burden, and the motion suggested there was a substantial relationship. There was no evidence of that. The counsel made representations to the court that support and custody were going to be issues. But while I was there, there was no motion filed regarding support or custody. As a matter of fact, the parties had entered into a stipulation beforehand that allowed the wife to have custody of the children. So
What's our review of the judge's decision? What's the extent of our review?
I'm sorry, Judge, I can't hear you.
Sorry, what is the extent of our view of the trial or the motion judge's decision?
I still can't hear you. I'm so sorry.
I think she's asking, what's our standard of review?
What's that?
What's our standard of review?
Your standard of review is abuse of discretion. I'm sorry, Judge, Your Honor. So it's an abuse of discretion. And that was, the case law suggests that a rendering of insufficient findings is an abuse of discretion. Well, in this particular case, there were no findings that were rendered. So it's obvious that there is an abuse of discretion by the court, by the judge.
But your request is to overturn the decision and not remand for findings.
My request is to vacate the order and to send this back.
We have a transcript of the hearing in the record?
Yes. Yes. I'm asking, Your Honor, for instructions to enter an order denying the husband's motion to disqualify. That's all I'm asking. That it be sent back and that the lower court be directed to enter an order denying the motion to disqualify. If the court would like nothing more, I'll rest on my brief. I would just point out, I noticed on page 18 of my brief, it appears that there's a typographical error or a Scrivener's error. The very last word on that page, wife, it clearly should read husband. It doesn't make sense otherwise, and I apologize for that. There was also one other error that I noticed, and it was in the appendix. At some point, I indicated that the order on the motion was entered on November 2nd. That's not true. It was November 2nd was the date that the motion was filed. November 29th, and it's clear from the record, it's just that in the table of contents, item number 7 on the table of contents, it has a statement for the date. It says 11/2 versus 11/29. And I apologize for that. I haven't found any other errors. Thank you.
Thank you, Attorney Brown.
Thank you.
Been submitted. The next matter on our docket is docket 23P0448, NM versus BS. And I believe we only have an appellant in this matter, too. Good morning.
Good morning, Your Honors. For the
Simons?
record, Joseph Simons on behalf of the appellant. Your Honors, I know that this is a fairly straightforward situation. This is an abuse prevention order appeal. Although, as you noted in my brief, I also call it a restraining order, the more commonly used term in the district courts. Your Honors, my client, being the appellant, was the sister of one of the plaintiffs. There were two plaintiffs at first. There was a husband and wife who initially came to court seeking a restraining order. And as you know, in the evidentiary hearing to extend the restraining order by a year, the court declined to adopt a restraining order for the husband. That's right.
But did it run for the wife and the child? Or
That's
no?
right, yes. So so what was extended was the wife and the then 13-month-old child. That's correct. Even though, interestingly, the court had made specific reference to there's no accusation against the defendant as to any threats or really any contact, anything at all toward the child. So we are asking that the court overrule the extension as to the child. There's 3 separate incidents that are referenced, not that there has to be any certain number of incidents, but there are 3 essential incidents that I would refer to, one being my client, the appellant, appearing at the plaintiff appellee's workplace. And what the context of that was, if you credit the statements of my client, were that there was a conversation in the plaintiff appellee's home, shared home, where the now plaintiff was complaining about abuse from her husband, the brother of my client, the appellant, and so that my client had gone to the workplace of her sister-in-law to try to allow her to continue that conversation because the brother/husband was home at the time. And
Did she go unannounced?
She did, yes, admittedly, she went unannounced, and I know there was testimony from the plaintiff, the wife, that that my
Made her
client.
uncomfortable. Was she present when the sister-in-law showed up?
She wasn't present, no, and it was a massage establishment, and the testimony from my client was that she was attempting to make an appointment. And I think that was uncontroverted testimony, that she was there to make an appointment to try to speak with her sister-in-law further. No evidence of any sort of threats or menacing behavior. I think there was some secondhand testimony, some what would otherwise be hearsay, essentially, but that was admitted that the sister-in-law was called and said there's a woman named, with my client's name at her workplace looking for her. But I don't think there was any mention of the specific wording or what was said, and certainly no indication of any threats or behavior that would warrant a reasonable person to be in fear of imminent physical harm.
So then we have the electricity or the circuit breaker incident at the house.
Sure, so the circuit breaker at the house, I'd say, like, if that's the second incident we're talking about, that would pertain to both plaintiffs, because it was not specifically, I don't think there was any evidence that that was specifically targeted to the sister-in-law, the current plaintiff here. And what the testimony was, I guess the most favorable testimony to the plaintiff was that the mother of my client and the brother/husband, who was staying in the home or living in the home. It's a little bit unclear if she lived there or was just staying there long term, but she was there, and she testified very briefly at the evidentiary hearing, and she said that she wasn't aware of any electricity being turned off. So I would suggest that the inference is that there was some sort of a separate zone in a bedroom that was affected. And my client's testimony, that didn't seem to be controverted, was that she flipped the switch. I think there was a mincing of words between the court and my client as to whether she turned off.
Why are they asking for a restraining order? What's going on here that prompts them to ask for a restraining order against the sister and sister-in-law?
Well, I think a fair inference is that they find her to be annoying and they don't want her around. I think that seems to be the case in the affidavit from the plaintiff that was extended, said that she comes every week or every other week. We don't want her to come every week or every other week. It seems to be just something that they don't appreciate, they don't want in their house. But that they never indicated in the affidavits or on the record from the transcript that they ever asked her not to show up. So there was never any time where they said, we asked her not to show up and then she still showed up, or we told her that we want her to call first and she still came without calling. There was nothing on the record. And instead, this is certainly a family situation. Families are complex. We can't really know the inner workings of families. Some get along well, some not so much, and then all in between. But certainly there was indication that there had been an ongoing relationship, that I think a fair inference that my client would attend or come to this home to visit, and the shared mother would be there a number of times. And in fact, again, going back to that incident, just to put a point on it, there was no indication, the mother didn't even know that the electricity had been turned off. And I think there was mention of heat and electricity. So I think without having a little bit more defined testimony, the inference is that it was probably an electric heating system in a zone, in a bedroom. I think that's probably the fairest and really only reasonable inference that can be made of the record. And what my client testified to in the court is that she didn't leave the home with the electricity turned off. She ultimately said that she had turned it off and then back on. She used some sort of a phrase about flipping the switch. And she testified that there was an issue, and that's why she went in to do so. So I think another fair inference could be that that same issue, after she left, went back. So maybe there was a quick fix, and then the electricity went back off. There's no indication that that was directed toward anybody, and I think that the court didn't discredit her testimony. In fact, it seems like the court sort of listened to everything. And
What do you see as the basis of the judge's decision vis-a-vis the sister-in-law?
Sure. Sorry, I think that based on the court's reaction to my client was that you can't go to someone's workplace uninvited. I think he seemed to hang his hat on that. And that is the only, out of the three incidents, that's really the only one that was only directed toward the current plaintiff and not to the brother-in-law.
Right. So the fact that he did not extend the order against the brother, do you think that requires us to infer that the basis of his decision to extend the order against the sister, vis-a-vis the sister-in-law, was based on the workplace incident?
Yes. I can't entirely say that because I suppose there's situations where could be a collective number of incidents and then just one more that sort of completes. But yes.
But the other two had to do with both of them, right? The other two incidents?
Yes, because it occurred at both their houses, and there was neither one was referenced or seemingly.
At their house?
It was at their collective houses, yes. So
if the fear is reasonable for one, it should be reasonable for the other?
Yes, because they were both seeking restraining orders. So I think that if a court, because it's an objective standard. Is a reasonable person in fear of imminent harm. So
what was the third incident? Is that when she came and was looking through the windows?
Yeah, so that was the third incident. I know we kind of worked it in a different order, but yes, so the second home incident was, so the one was with the breaker, and then the other one was where she comes in and she's accused of having looked in the windows, and the sister-in-law / plaintiff said that she I think she knew that she was at the door or heard her dogs barking and then didn't hear the doorbell ring but heard what sounded like someone trying to open the door. So
I thought she testified that there was banging on the door.
she may have said that there was banging on the door, and I think she said that it sounded like someone was trying to open up the door.
Okay.
And that was on a day where the sister-in-law testified that she was home and that I think by all accounts the mother was to come that day, but I guess later in the day she was supposed to come in by airplane. But yes, to the point of the similarly situated plaintiffs, I mean, they're both, if those were the only two incidents, it would be certainly an abuse of discretion for a court to find that one was in reasonable fear of imminent physical harm and the other was not. I mean, it's the exact same situation. Nothing about that incident, even though the sister-in-law was home, would suggest that my client knew that the sister-in-law was the only one home or was going there specifically to speak with her or target her in some other way. So, Justice Shin, to your question, though, what is it that the court, so the third incident is the one where my client goes to the workplace, and again, it seems to be a workplace where it would be typical for someone to come and request an appointment just like a hair salon. It's a massage parlor. So it's not as if it's a place that's not open to the public or not typical for the public to come.
So she says that at 9:20 she's working in the kitchen, the dogs bark, she gets up to check out, the baby in the room, looks around outside, the dog stops barking, she sees the sister-in-law walk to the front door. She's waiting for the door to ring, but it never does. And she listens and she hears somebody's trying to open the door, but the door's locked. She turns the lights off, looks out the windows. She calls her husband and calls the police. So should we infer from that that made her scared?
Well, I think that the question really is, would a reasonable person have been afraid in that situation based on the circumstances that are known?
Somebody's trying to come in the house at night when they're home alone?
Well, there's a lot of different scenarios. If it's a stranger, certainly I think you could make that inference, absolutely. But if this is based on a history of a sister and a sister-in-law coming to the home every week and also having a mother who seems to be living there, or at least is there regularly and coming back that day, that puts it in a much different context. The pendulum swings to that. The inference should automatically be that that's a reasonable thing for somebody to come there, and there has to be something else to kind of push it toward a either nefarious or really threatening type of situation. So
How do we reconcile what she said there, that's from her affidavit, with what she said at the hearing, which is that someone was banging on the door?
Oh, that must be where the question was, and I was more focused on I guess I had looked at the affidavit more recently. Well, I think that the court could have discredited the plaintiff's testimony or her veracity at that point. I don't think that the court necessarily had to. I guess banging and trying to open a door could sound similar, or dogs barking and sort of going on high alert in the home could cause similar sounds. I mean, she didn't testify that she saw her. She testified that she heard sounds. But I think, if anything, that sort of goes against the plaintiff's veracity if the court were to note the difference in what it testified to. And I think banging on the door actually helps my client, because if my client was banging or knocking, I mean, it's not really clear how loud or how long, but someone could say banging on the door, knocking on the door could mean the same thing. That sort of goes to a more reasonable inference of someone coming over, knocking on the door, seeing if someone's home, and then leaving once the lights are turned off. Maybe that's a clear indication that the people inside don't want to be visited.
I would say banging on the door, knocking on the door. You picture the same thing in your mind's eye?
I think there's a spectrum of, maybe not exactly the same, but I think within a spectrum. I mean, certainly like when the police are coming with a search warrant, they might bang a little louder than somebody that's a neighbor looking for a cup of sugar. But I don't think there's enough context to conclude that there was anything threatening about that. I don't think there was any testimony or evidence to suggest that that was something that would put a reasonable person in fear. Again, given the context of the relationship that we know based on the record. For all the reasons I've stated and all the reasons in the brief, I would ask respectfully that this court issue an order overturning the extension of that restraining order from the plaintiff/sister-in-law. And unless there's any questions, I would...
And child.
And, I'm sorry, yes, and child, yes, and child. Unless the court has any other questions, I would rest on the brief and the arguments already made.
Hearing none.
Thank you very much,
Matter
Your
stands
Honors.
submitted. Thank you. And our last matter for the morning is docket 22P1039, Scott C. Smith versus Harmon Law Officers and another. And Smith? Isn't the lawyer appealing the sanction and the other ones? Mr. Wasser?
Thank you, Your Honor. Attorney Brian Wasser for the appellant Scott Smith. Distinguished members of the panel, because this is primarily a debt collection claim, we're asking the panel not just to vacate the lower court's judgment, summary judgment in favor of Chase, but J.P. Morgan Chase, but also to reverse and enter a finding for partial summary judgment in favor of Smith as the non-moving party on the limited issue of liability for debt collection violations. Now, notwithstanding the broad discretion of a trial court, no court has the discretion to exclude a prior inconsistent statement by a party witness. In this case, the lower court abused that discretion when it denied Smith's motion to add the prior inconsistent sworn statement by Chase employee Cynthia Riley, whose blank endorsement appears on the 2006 Washington Mutual note.
That was in a Riley's testimony was in an unrelated matter. Let's start with that. Is that fair to say?
It is fair to say, but so she's not.
Hold on.
Yeah,
So hold
sorry.
on, let's just stop with that.
Yes, yes, Your Honor.
And that was the subject of a discovery request. Is that fair to say?
It was a deposition testimony, so in that regard, yes.
The testimony in the unrelated matter, you wanted to bring into this case,
Correct.
and you motioned for it in a discovery motion, or no?
Oh, yes, so we had written discovery that would have implicated such a statement, yes.
Okay. And Chase objected to it?
Yes, Your Honor.
Okay. And then what happened?
Well, we had a lot of motion practice. We had some moments in time where, first we had dispositive motions, some of which narrowed the complaint. We had moments in time where we were under...
Ultimate ruling with respect to that piece of evidence?
Well, we never got to a motion to compel because there was protective orders in place at various times, but they were piggybacked on one another, so it was a complete chain of time where we were not allowed to move to compel.
And so, is it your position that somehow Chase withheld that evidence?
Yeah, well, I think there's a lot of reasons. When you're a debt collector, you have to communicate accurately with the debtor, and you have to treat them fairly, and you have to be honest about everything about the debt. And so if you are arguing that you purchased a note from the FDIC in 2008 in a receivership, as in the capacity of being a receiver for a failed bank, and then you have information, you know that this blank endorsement indicates that that note was sold to the secondary market and no longer even an asset of Washington Mutual, then yes, you need to disclose that.
Well, they objected to the discovery request as overbroad. Seemed to me to be a pretty valid objection. And then why isn't it your burden to move to compel?
Well, we don't really know what a court would do because we never got to the hearing on a motion to compel. So that needs to occur.
There was no motion
It would
to
have been
compel,
Did you
was
file
there?
a motion to compel?
No, we had a Rule 9C conference in preparation for the motion to compel, and that's when Chase then filed its motion for protective order.
Which was well within their right?
That's correct.
This was at after the close of discovery, right?
I believe it was at the close of discovery, yes.
And the judge, the basis of his or her denial of the motion to add the papers, the deposition transcript, was that it was untimely. So how is that an abuse of discretion?
Oh, no, I don't believe it was untimely, and so...
Well, that was the basis of the judge's decision, was it not? That you had this transcript for a few months, and you waited and filed it as an emergency motion, and the judge said that that was improper and untimely.
No, I think what the judge was getting at there was that was the basis for the sanction, saying that it should have been moved for earlier because as the judge explained it there, it took too long for the plaintiff to file his single justice appeal.
The decision on the motion to file additional papers says that, in essence, this is trying to file a surreply without exceptional circumstances.
Yeah, and, we take issue with that, obviously, as they're two different...
It's an abuse of discretion standard. So how is that an abuse of discretion?
It's an abuse of discretion because it constitutes a prior inconsistent sworn statement by a party witness, Rule 801D1A. And the cases we cited indicate that no court has the discretion to exclude a prior inconsistent sworn statement.
If you had done it on a timely basis, the matter might be different.
So, yeah, I think we're talking about two different things on timeliness. The tracking order to request discovery had terminated, but not the time to receive the discovery or file motions to compel. And then the other timeliness issue, and I'm not sure if that's what you're talking about, Judge Singh, but the other timeliness issue goes toward, I thought it was more in the context of the sanction, but, we had the transcript, we were aware of the transcript ahead of time, but there was motions to strike the summary judgment motion, so it would have rendered doing that at that time moot. And so when the motion to strike was denied, then we moved for the additional papers. And this is just, again, just to bring in this...
To strike the summary judgment motion.
Yes. That was in there as well. So we had a motion to strike summary judgment motion. Lower court denied it.
Under what rule did you bring that motion? Of civil procedure?
I'm not sure, just a general motion to strike. We had grounds for it in the motion.
Strike the motion. What was the argument?
I think a part of it had to do with matters that were previously decided and re-argued like 2 or 3 times already. So I think that was a big part of it, yeah. And then we did the single justice appeal, which the law provides 30 days to do that. That's the time it took. And so we were timely in requesting to have this added as additional papers because, first of all, it would have made summary judgment inappropriate because we've got this outstanding discovery, and secondly, because it's a material fact that the court doesn't have any discretion, quite frankly, to exclude. And we weren't asking Chase to provide it. We had it at this point. We found it on the internet. I mean, yes, it took time from the time we found it to the time we were able to authenticate it. That's two different things. I don't think that's on the record, but, oh, actually it is in the...
You weren't asking Chase to provide it?
No, we already had it at that point. Yeah, we had it. We found it on the internet, and then I had to do some background checking. I contacted the law firm that conducted the discovery. I contacted the reporting company that did the deposition transcript to make sure that this was an authentic thing, because, you're just getting something off the internet. And that was done like 2 or 3 days before the motion to add the papers, that we actually authenticated it. Yeah. And so I think on that setting, that's not the kind of setting on which a court should be looking to, penalize or sanction a party or an attorney. Rule 11 is very clear. You've got 3 elements. You have to review the pleadings, make sure there's grounds to support it, in which case, we had grounds to support it. As I just indicated, this is a very coveted piece of evidence that even a court doesn't have
How does the
discretion to
Riley
exclude.
deposition have any bearing on the ground the judge relied on in granting summary judgment?
Well, what it does, it undermined Chase's ownership by purchase story, but then Chase...
Right, but that's not what the judge relied on.
Correct, so I'll cover that right now. Yeah, so the judge relied on Chase's argument that it has bearer paper. Well, the problem with the bearer paper argument, first of all, it's changing its story. As a debt collector, you got to be careful about doing that. But we have this outstanding request to inspect the note. And so that's an outstanding...
So my question was, how does the Riley transcript bear on the judge's rationale for granting summary judgment?
It wouldn't play into that, Your Honor.
Okay.
Yeah, thank you.
Did you not have an opportunity to inspect the note?
No, Your Honor.
Never?
Never.
You didn't inspect it in court?
When I say inspection, Your Honor, I mean having an expert document examiner
That's
look
not
at
what
it.
I mean. Did you inspect it in court?
My eyeballs saw the document that they waived in court, yes, and it didn't have punch holes in it.
Okay.
I can tell you that, yeah. I'm not the expert, and I'm not the attorney. I can't give evidence anyway. But yes, Your Honor, that did happen. They waived a piece of paper in court, yes.
Well, it wasn't waived. You had a chance to look at it, right? You, the court, looked at it. You
Yes.
had an opportunity to look
Yes.
at it and examine it.
Yes, for whatever good that did me or the judge, yes. But the court never made a specific finding looking at the document saying, oh, this is an original. Yeah, that didn't happen. Okay.
Well, the court said there was no reason to doubt that it was, right?
Oh, goodness, yes, there was a lot of reasons. We have, we had the affidavit of Wilkin Rodriguez. We have actually, I think the best piece of evidence is the facsimile from the original law firm that showed punch holes in their copy that they faxed into the originator before.
Wasn't that reasonably explained away?
No, and it can't be explained away because that's weighing the evidence, and it's just, we're talking about summary judgment context, so you really have to have, that's a toehold, if nothing else. And the other thing is, what is Chase's evidence that it has the original? The attorney certainly made the representation, but like I said, just the same if I made a representation, that's not evidence. They only had the affidavit of Jeremy Summerford, which was a deficient affidavit. It wasn't admissible. He didn't have personal knowledge. He didn't have competency.
Did you argue that below?
Pardon me, Your Honor?
Did you argue this below?
Yes, we did, Your Honor. Yes.
You did?
Yes.
Where did you argue that?
I believe it's in our, if nothing else, it's in our motion for reconsideration, Your Honor.
Well, that's
might be in
too
the-
late.
It may be in the primary brief, Your Honor. I just, off the top of my
Well,
head,
I mean,
don't want to misrepresent to the court.
our cases say that bank employees can testify as to their review of business records. So let's assume it's admissible. It seems that the documents attached to the Summerford affidavit, in particular the loan transfer history, show that the note was possessed by Washington Mutual prior to the receivership. And therefore, it was one of the assets that was conveyed through the receivership. So what did you offer to refute that?
You're right, because this is just data entry notes. And when you look at the notes, you'll see this indication of A01, INV A01.
Yeah.
We have a document that's not a Chase document, it's a Washington Mutual document. And INV A01 refers to Washington Mutual Asset Acceptance Corporation.
The Summerford affidavit says it refers to Washington Mutual. And there are documents attached that show that it refers to Washington Mutual.
Right. But Summerford he can't testify as to what Washington Mutual codes mean. He's not familiar with
They're in the documents that are attached to his affidavit, the business records.
Well, as you saw, Your Honor, there's also a stipulation in another case that Chase entered into.
Which they immediately disavowed.
They disavowed, but the court issued an
And
order
that
denying
doesn't
it.
matter. I mean, you're trying to use that as a judicial admission, but judicial admissions can be corrected. So I don't see how that raises a material issue of fact as to what code A01 means.
So I would say, the bottom line, Your Honor, is here's the problem. Even if we assume that they had this original note and it was endorsed in blank and it would otherwise be bearer paper, the problem is that's not the operative document. That's not the operative debt instrument. There's a second debt instrument, and that's the 2008 Washington Mutual loan modification,
Okay.
which, by the way, is specifically endorsed to Washington Mutual. It's a specific endorsement on there. But you don't even have to decide that issue. It's just enough for this court to see that from 2016 to 2018, when the time this complaint was filed, Chase was trying to enforce the four corners of a 2006 Washington Mutual note, and those weren't the full, complete terms. The 2008 modified note from Washington Mutual, that would have changed those terms, and it's a debt collection violation to misrepresent the terms of a debt.
Did Smith have an obligation to pay regularly on the loan?
Well,
When was the last time he
not
paid?
anymore, Your Honor. It was
When was the
discharged.
last time he paid?
I believe after his discharge in bankruptcy in 2012.
2012. And is he still on the property today?
Yes, Your Honor. Or at least his wife is, yes.
What do you mean when you say that the 2008 loan modification was specifically endorsed to Washington Mutual? It's a modification agreement. It's modifying the terms of the note, but I don't understand how that changes the endorsement.
Well, that's a judgment call, Your Honor, but it's it's listed, it's payable to, they're doing a deal with Washington Mutual, and Washington
Right.
Mutual doesn't say anything in its
But
modification
that
to
doesn't change
preserve.
that doesn't change the endorsement on the note.
Well, even if it doesn't, Your Honor, it still changes the terms, and this is
That's correct.
strict liability for misrepresentation of terms. The issue is not for us whether Chase has the right to enforce the debt. It's whether they did it correctly under the regulations. I mean, Chase is claiming that they have standing to foreclose, and in their foreclosure notices, you know, they're saying that there was never an assignment. It's in the foreclosure notice themselves. But we later, through discovery, found out there was an assignment to Chase, 2013 assignment, which was not recorded, which violates strict compliance with the power of sale, Chapter 244, Section 14. That would require that assignment be recorded before they can foreclose, and it requires it to be listed in the notice of foreclosure before they foreclose. So had they gone through with that notice and actually foreclosed, it would have been a void foreclosure for failure to strictly comply with the power of sale.
But no
Again,
foreclosure has taken place so far, right?
We're not there yet.
well, actually, the one has, but it's not before this court. It's in a separate matter. Yeah.
And I see your time's running out. Did you raise some issues for the first time on appeal that you didn't argue below?
I don't believe so, Your Honor, but, you know, this court has de novo review over the summary judgment record, so, you know, everything's fair game in the summary judgment record, Your Honor. So you can review these things, and you can review the affidavits and see if they're admissible. So, you know, I see the balance of my time is up. If Your Honors don't have any further questions, I'll rest on my brief and my reply brief. Thank you. It's both a personal and professional privilege to argue before you today. Thank you so much.
Thank you, Attorney Wells. Attorney Bazar?
Good morning, Justice Desmond and Your Honors. My name is David Bazar, and I represent the defendant appellee, J.P. Morgan Chase Bank. We're prepared to rest on our briefs subject to any questions that the court might have for me.
So how about you just touch a little bit on the Riley deposition that was part of a very broad discovery request
Yes, Your Honor.
that hadn't been ruled on, I don't think. Had it been ruled on?
In the other case, Your Honor?
In this case? You looked for a protection order. You said it's overbroad.
So yeah, the way that this came up, Your Honor, was that we received a document request that was as broad as could possibly be. It basically said, produce everything from every other case in the history of Chase
2006.
from other litigations. And we rightfully objected to that and said it's grossly overbroad. We couldn't even tell from that what they really wanted or what could be potentially relevant to their case from the grossly overbroad scope of that
Why do you think
discovery
they brought
request.
that motion?
I'm sorry, Your Honor?
Why would you, if you had to,
Why did we bring motion for protective order?
no, why did they bring the motion for all of that discovery?
So it wasn't a motion, Your Honor. They just served discovery requests, and this panel's correct. There was no motion that was ever served. So the court here could not have. You're on appeal, and the issue here is, did the trial court issue a ruling in error? That's what this court has to decide, not whether Chase should have produced some document or not. And so the issue before you, there's no decision for this court to rule on, because the plaintiff never filed a motion to compel, as the trial court recognized in its summary judgment ruling. So there was nothing for it to rule on. It's up on summary judgment. It has the record it has that's been presented to it on summary judgment, and discovery issues are not before the court. And the reason that they weren't before the court is also because counsel didn't file a Rule 56F affidavit. So there was nothing pending before the trial court judge to actually decide in the context of discovery issues.
But isn't part
Counsel,
of the allegation that by not presenting the document, you're somehow committing a fraud on the court?
Well, I think that came up in the motion for reconsideration, is my recollection. It's the first time that was raised. To get, I think, to what Your Honor's really asking me about, is there anything relevant in that document? I think that's really what you want to know. And the answer is no. There's nothing relevant in it. She was talking about another loan. The time period was actually different. So the time period she was talking about, the codes, these codes change over time. And there is testimony in the record about that. Excuse me just a second. Now I'm going to have trouble finding it. Just a moment. So anyway, there's testimony in the record about that, which I will provide a cite for, in which the issue is that by the time that we're talking about Mr. Smith's loan, the investor code is a different code that Chase was using. It was X01, or X, all right. Excuse me. Yeah, here it is. So the investor code of A01 is not a third-party investor code. So counsel was citing the second appendix of the record, which included basically a WAMU privacy policy and something else. The Summerford March 16, 2020 affidavit says that between June 30 of 2008 and December 19th of 2008, the owner of plaintiff's note is identified by an investor code A01, which is that loan transfer history screen that's been talking about here. Between April 3rd, 2008 and July 21st, 2009, investor code A01 represented Washington Mutual Bank, which is attached to those confirming documents, which I think is what Justice Shin was getting at. But as of March 9th, 2020, the investor code for Smith's note is X62. So that's the correct code, X62. And that is attached there. It's attached to the master maintenance and display screen for Chase's MRP. And investor code X62 represents JP Morgan Chase Bank and reflects that JP Morgan Chase Bank, N.A., is the current owner of plaintiff's note. And that's at Appendix 2, page 227, paragraphs 6 through 10 of the record. And I think it's worth noting that Attorney Wasser deposed this person, Jeremy Summerford, the designee for Chase, and never asked him a single question about this during his deposition. And he already knew by that time about whatever was going on, whatever he thought was going on with the investor codes and this person, but he never asked any questions about it at all. If he had, he would be putting that record in front of you, and he didn't. He didn't ask.
So the court...
Counsel,
I'm sorry, go ahead.
I just wanted to ask a question about the Rule 11 sanctions issue. Could you clarify, was there an actual hearing where counsel had noticed that there was that Rule 11 sanctions was being considered? I understand that there was a hearing set up for the amount of sanctions.
Yes, Your Honor. So the hearing was not a Rule 11. There were two hearings. The first hearing was not a Rule 11 sanctions hearing. And the court imposed the Rule 11 sanctions after the hearing sua sponte. So there was no motion for Rule 11 sanctions that the court had before it was ruling on. And when it issued its ruling on the finding a Rule 11 sanction, it did that sua sponte. And my recollection is that the court did not mention anything during the hearing like it was predisposed to enter some type of Rule 11 sanction. So I do think that Attorney Wasser can fairly claim that it was a surprise to him after the hearing that he had been sanctioned under Rule 11. And if that's all there was, you should rightfully grant his appeal. But that's not all there was, because after that happened, the court permitted substantial briefing, right on allowing through Attorney Wasser to file a surreply brief, and then afforded him a full and fair second hearing on the issue from A to Z. He wasn't prohibited from covering anything he wanted. And he did go back and forth with the judge over whether or not he should be appropriately sanctioned under Rule 11. He had the full and fair opportunity to present an affidavit from himself if he wanted to do that. He chose not to. He had a full and fair opportunity to request an evidentiary hearing or other hearing. He chose not to. All he did was submit briefing, and then the court issued its second ruling where it said, okay, I'm imposing my Rule 11 sanctions, and the sanction is a mere $750, which was a substantial reduction of Chase's attorney's fees that it had incurred in all of this, which the judge said he was looking at for what would constitute an appropriate sanction amount.
Do you have any Massachusetts appellate cases that support this bearer paper ground that the judge relied on in granting summary judgment?
Yes.
Because the judge cited only Superior Court decisions.
Right, I was going to say, so the judge, I believe it's an unpublished decision, but the second decision that this court reached in the Starkey case.
The Starkey, is that what you said?
The second Starkey decision.
Okay, and that's unpublished?
It's an unpublished decision.
Are there any published appellate decisions that support this argument?
Not that I recall. We certainly would have cited them if we had, in our brief, if we'd come across any.
You cited Mitchell, which is a rescript opinion that it's not entirely clear to me what's going on in that decision.
Well, I think, Your Honor, if there's no decision that the court can cite to that's direct on this, this is statutory in Massachusetts, and it's the UCC. So this is not, and also, I know there's at least dicta in some of the SJC and other opinions about this. Excuse me. It's a big case, and so I have a lot of notes. In fact, this is the biggest bag I've ever brought to an appellate argument. It's about yay big with all the appendices. My recollection is that there is at least some dicta in some of the appellate case law saying that, other than the Starkey case, which I think is maybe it's not binding because it's not published, but I think it's more on point, that an original note endorsed in blank is bearer paper and can be enforced by possession alone. That is, by the way, an incredibly uncontroversial point of law. It's the UCC, it's statutory in Massachusetts, and frankly, it's why notes get endorsed. And this is so you don't end up having lengthy battles and disputes and discovery and all kinds of messes over who owned this thing and when did they transfer it and to whom. And it's just, you have the paper, it's in your hand, you can enforce it.
Still got 4.5 minutes left.
Okay. Well, I guess to close then, just briefly, the summary judgment ruling of that Chase is the person in possession of Smith's endorsed in blank note and can enforce it in that capacity was correct. It was unrebutted by any admissible evidence. The discovery issues that are in this case were never in this case because they weren't brought to the court to be adjudicated in an appropriate fashion, and therefore they were not incorrectly decided, which is the key to an appeal. And then, of course, we haven't talked about them, but there are all these alternative grounds that are in our brief if for any reason the court were to decide that the reason that the trial court ruled upon was insufficient. We would argue the sufficiency of
You own it.
Of the other points.
That you own the note.
That we own the, yes, sir. I don't think the court needs to reach the issue because it can simply affirm the trial court's judgment. But if it doesn't simply affirm the trial court's judgment and it wants to go past it to get into other issues that were briefed to the court below and were not decided by the court below. So that's the key, is that we briefed them, we asked the court to decide them, it declined to decide them, it only ruled on the simpler issue of you have possession of the note, you can enforce it in that capacity. But if the court were to say, well, no, gee, that judge was wrong, we're going to reverse on those grounds, then the court should address the other issues that were properly briefed before the court, upon which we propose we would prevail on in the alternative. If there are no further questions, I thank the court for its time and attention.
Thank you, Attorney Brazil. Thank you, Attorney Walsh. Both sides well argued and very helpful to the court. Appreciate it. The matter stands submitted. And that concludes our business for the morning. Court is in recess.
All rise. Thank you, sir. School will stand in recess.